Can I now please request Suva Mandal to address the audience?
Thanks, Niyati. Honorable Chief Justice, Honorable Judges of the Bombay High Court, a lot of my seniors here, fellow lawyers. It's a great pleasure to be speaking in front of such an august audience. Madhukar mentioned that it's incumbent on the young generation of lawyers to take this forward on changing the arbitration landscape in India. I think that is largely true, but I think we need the guidance and support of the existing generations and their learnings, because I think we are in that threshold, like in many sectors of our economy, where we have the ability to make that change. And it's a window that won't come again and again. The next 10 years will see probably tripling of the Indian economy. And with that, for business houses like ours, I think the rest of the institutions will have to play a very key role in supporting that growth. And it's not easy. And we are harsher on ourselves than we need to be. There are a lot of impressions about the arbitration system, the judicial system. That is not all true. There are a lot of positives. I think if we look forward, the crux of the issue is what is it that we can do to support this growth that's going to come into India. And if you historically go back, in the traditional way of the three pillars of our constitution, the government, the legislature, the judiciary, if there is one pillar that has time and again withstood attacks, built its reputation, won the confidence of people, it's the judiciary. I mean, that is one point we need not debate much. But with that also lies the opportunity to set in place an alternative dispute resolution system and the arbitration system. So what has really happened over the last 2 years that we keep speaking about this changing landscape? I mean, sitting in a business house, I can tell you, we've taken there's a general, if I may, it is not the right word to use, but I think it'll easily communicate the idea. There is more of a respect for, there's a fear of the enforcement, if I were to put it very clearly. There's a fear of the enforcement. Whether it is the regulatory system, whether it is the judicial system, and what was missing in the arbitral system. It is, I mean, if you really step back, we spend many hours discussing enforcement of awards. It's a chapter in itself. But, on a lighter vein, the fact that awards, there's a discussion on enforcement of an award, it kind of beats the issue. An award is an award. It is there to be enforced. So I think what really needs to happen is there is a general respect among people for these institutions that have now evolved. Litigation has never been a win-win situation for businesses. It's never been a win-win. We spend several hours, much more than we spend in courts, trying to avoid litigation. But with the growth in economy, we will invariably be left with a situation where we will be left with those outlier cases which go into the dispute resolution. And people are looking for effective, speedy remedies, not because they like speedy remedies, but because, very simply, the cost of capital in getting locked in litigation, not in terms of costs is, of course, a large part of it, but the fact that the principal issues of capital are locked into it makes business and projects unviable. And therefore, the speediness of the arbitral system. There are low-hanging fruits. There are several big things we can do, but there are few low-hanging fruits that can change it. For one, And on a much lighter vein, there are more lawyers than non-lawyers in this room. The arbitral system needs a greater and more active participation from arbitrators who are non-lawyers, with the non-judicial mindsets, necessarily. Because an arbitration is not the classic adversarial system of dispute resolution. There is a consensus approach. There is an expert approach. So I believe if institutions like the MCIA also start inducting, promoting, if you may say, a non-legal approach to some of these arbitral resolutions, that facilitates both the legal approach plus the respectability that these awards and the enforcement of these awards in the judicial system. I think the second point, which can be greatly helpful, it would be the rules of natural justice. Natural justice is fundamental to business, to resolution of disputes. But typically, as a general rule, the parties involved in arbitrations have a certain sense of sophistication, have a certain sense of understanding of each other. There needs to be a slight relaxation of those rules, because of which people tend to abuse those rules more often than actually benefiting from them. So that would be of great advantage if the general direction in which arbitral laws develop is towards a more relaxed approach to enforcement of natural justice rules. I think what institutions like MCIA are doing is that they've started the trend of preventing the export of the legal profession. It is not that arbitrations were not popular in India. They have always been. But it's been exported. A lot of major arbitration, for lack of the institutions, has exported, like several things that have happened to the rest of our country. Capital markets have got exported. Industries have got exported. I think here is the opportune time for us to bring us back, all these institutions back into this country. We need not have 153 cases in the SIAC, as we saw in 2016. We could have had at least 50 of those cases in MCIA. I think so. What is required for that is a proper system for arbitration. And that system is, again, institutional arbitration, pardon me saying this, is often confused with just good conferencing facilities. I think that's a very small part of the arbitration. The heart of the institutional process are the rules, are the emergency arbitrators. It is the alacrity with which rules are enforced. It is the fact that there is a time process through which it can be resolved. I think the culture is developing in India. There are a few steps more to go, but I'm confident we'll get there. Coming to the changing landscape, I think I can tell you, business houses are worried. There was a time when several of my colleagues in the business industry would say, oh, it's a litigation. It doesn't matter. It'll take 9 years, 10 years. It's okay. We'll play it out. I think people now think, rightly so, what is it that we can do to resolve it? People are taking their contracts more seriously. And I think if the arbitral process develops a lot more, it will help in that a lot more. Last but not the least, which I started off, I think there is an increased requirement to have experts, technical experts, valuation experts, accountants, playing a more active role in arbitrations. Because a vast majority of disputes that go into arbitrations are not about, per se, legal principles, as much as it is about complex oil and gas contracts, complex valuation issues, what are the principles to be adopted. Typically, people rely on experts to depose before an arbitral tribunal comprising judges. Experts will be experts, but the determinators of the dispute need to be people with that technical skill sets. So it's important that as institutions, we socialize the concept of arbitrations outside the legal fraternity, because a lot of value is also there. I think, I'll be hearing the debates later on today, but I think we are posed at a very interesting point. We have a evolving arbitral law. Judicial interference has significantly reduced. I think there's more clarity in the laws. The overarching principle of public policy has been diluted. People feel more confident. I must specifically commend the Delhi High Court has specifically gone a long way in enforcing awards, especially foreign awards. They've not balked at large amounts. They've not balked at, that these issues will trigger challenging well-established Indian legal principles. There's a general concern amongst defendants, people who challenge arbitral awards. What is going to be the security deposit I have to give? It's a good concern. It means you're not going to go scot-free on an appeal process for the next 6 years just because the system gives you that chance. So I think we are well posed. The doing business in India controversy, I think the legal process, the legal enforcement, we need to up ourselves there. And with that, I'd like to thank all of you and welcome all of you. And we look forward to a great conference today. Many thanks.
Thank you, Suva, for your expert industry insights. May I now invite Honorable Justice A.K. Sikri to address the audience.
Good morning, everybody. My esteemed and revered Chief Justice, Justice Dipak Misra, and his wife, Mrs. Misra, sitting here, Mrs. Manjula Chalur, Chief Justice, Bombay High Court, judges from Bombay High Court, past and present, dignitaries who have come from other countries, many very, very familiar faces in arbitration world from our country who are really the torch bearers. My wife, ladies and gentlemen, or should I use the expression I learned, I think I should send that message also. There was H.R. Khanna Memorial Lecture which I was supposed to give, and it was presided over by Professor Bakshi. So he said that even in addressing ladies and gentlemen, let us now use neutral term. So gentle persons instead of ladies and gentlemen. So I can say, and all gentle persons sitting here. Let me first congratulate MCIA for organizing this second annual conference. As it shows that MCIA is barely 2 years old, and within this short span of time, it has really traveled a lot. And not taking baby steps, going by the age of this institution, but big leap forward. It has been recognized in India. It has made its presence felt in international community, and I think it is going to do well in near future as well. And when we talk of this subject, changing landscape of arbitration in India, I'm sure that it is going to play a pivotal role in the process. Coming to the topic, I start with narrating 3 instances, I can say, or 3 features or 3 anecdotes. First is, couple of days ago, it came in the newspapers that in ease of doing business in India, ranking of India has jumped from 130 to 100. 30 steps in one stroke, which is a big achievement. And if you had read the reasons which the World Bank has given, two main reasons were that we have made significant statutory changes in arbitration law, bringing it in tune with international standards. Of course, that was the purpose when 1996 Act was enacted, but going by the experience as to how it worked and certain difficulties which were faced and which are sought to be overcome by these amendments. And second was bringing the legislation insofar as insolvency regime in this country is concerned, that is IBC, Insolvency and Bankruptcy Code in India, which is again a very, very significant statutory step. Second, I remember it must be in 2005 or 2006, we had gone to Singapore, few lawyers from Delhi and judges. We were led by Justice Lahoti. And we had interaction with Singapore International Arbitration Center, SIAC. It was their invitation to us. Of course, after visiting SIAC, their premises, in the afternoon there was an interactive session with 3 speakers from Indian side and 3 speakers from Singapore were to speak. Among speakers, Justice Lahoti, of course, was there, I was there, and one president of our Bar Association at that time, Mr. Chandok, he was there. First, we were to speak. We were speaking what is the statutory regime as far as Arbitration Act is concerned. And in those days, difficulties which were faced because of Bhartiya International and ONGC saw pipe. So we were almost defensive in trying to explain the reason behind those judgments and how those judgments are still not the roadblocks. When it came to Singapore, the 3 speakers who were there was the secretary or a CEO of Singapore SIAC, Attorney General for Singapore, and one judge of the Supreme Court of Singapore. They didn't talk about what the law is and the nuances of law, statutory provisions, etc. Chorus was, look, SIAC is best, come to this country, and the infrastructure and other thing, that is what SIAC representative said. AG said government has full support to this SIAC and how government is ensuring that it works. And Supreme Court judge, I still remember Justice V.K. Raja, he said that, look, judiciary is also supporting not that SIAC in particular, but arbitration culture in this country by minimal interference. So Singapore has the best environment, best atmosphere. Third incident which I wanted to share is last month only, SIAC had its conference in Delhi. Our Honorable Chief Justice was the keynote speaker in the evening, if you remember, sir. We had gone there. And immediately after, in that session, our Honorable Chief Justice spoke, and the minister from Singapore was there. She spoke. And thereafter, there was a panel discussion of lawyers from other countries, which was moderated by Mr. Nankani. And the topic was hard talk. That they were discussing whether, and it was hard talk about the arbitration system as such, which has come under some ridicule for some reasons. So whether there is future for arbitration at international level or not. The purpose why I have narrated these three instances, as I progress further in my address, I'll share with you. Coming to the first, that in India ranking because of these statutory amendments. The aftermath of Bhatia International and ONGC saw pipes case, it was felt necessary that some amendments are necessary across the board. Law Commission was given this task, and on the recommendation of Law Commission, these amendments came into existence. Everybody knows, I don't have to say much on that. But what I wanted to emphasize here, which was in emphatic manner emphasized by our Honorable Chief Justice in that SIAC address also, that look, there has always been a problem as to the purpose of arbitration, whether it is served by arbitration proceedings or not. The two things which were required, that it has to be cost effective and it has to be expeditious procedure where proceedings don't take much time. That was not happening in our system, which are taken care of by the amendments. There's a cap on the fee and there's a time limit which is provided to the arbitral tribunal to give the award, by which time they have to give the award. There is a thrust on institutional arbitration because ad hoc arbitration with five-star culture and not arbitration culture, which was prevalent in this country, that has to be taken care of. That has been emphasized in these amendments. And this has, coupled with IBC, as I said, has put India within 100 countries insofar as ease of doing business is concerned. Now, once these two things are there, still delays take place because of certain other reasons. And it becomes still a costly affair because of certain other reasons. And on that I admire the topics which are chosen. First is on the arbitration clause itself, how it has to be worded. It has been the experience that when these contracts which are entered into between the parties, all details are worked out very minutely insofar as whatever is the subject matter. It's a collaboration agreement, suppose one party has agreed to give its know-how, etc., to the other party, or investment which is being made. But when it comes to arbitration clause, why up to now at least not much effort is made, and maybe cut and paste policy is adopted. And particularly in international arbitration, that became the area of concern and gave to, if we talk in the context of what happened in India, starting from Bhatia, seat of arbitration, and whether under Section 9, Indian courts can interfere with even those proceedings which are going on outside. So these disputes had been there. Peculiarity insofar as international arbitration is concerned, that there are three sets of laws which apply. There is a law of contract, which govern the relationship and how the contract, etc., is to be interpreted, various clauses, which law would prevail, law of which country. There's a law of arbitration agreement, which may be different from law of contract, which is lex arbitri. And there's law of conduct of arbitration proceedings, which we say curial law. And it has given rise to where is the seat of arbitration, where is the venue of arbitration, and all those nuances. From Bhatia, journey up to Balco, and thereafter Reliance 1 and Reliance 2. As far as Reliance cases are concerned, I have been a party to these judgments. And we felt that all this could have been avoided if there was proper arbitration clause, particularly about the seat of arbitration and venue of the arbitration. So therefore, first session, and it would avoid delays, because if there is a dispute as far as constitution of the arbitration is concerned and where the arbitration should take place, and the arbitration process doesn't get started, naturally the clause which is in the arbitration law that this dispute is to be, or the award is to be made within 12 months, won't get triggered. But delay takes place. Dispute has started, but the parties are still struggling as to where this arbitration proceedings are to be conducted, which is the seat of arbitration, because much depends on that, when ultimately which is the court which has the jurisdiction to even at the interim stage or at the final stage to deal with such an award. So therefore, this becomes very, very important, and it can avoid delays. Now come the second stage, as I said, the conduct of arbitration proceedings. Now, insofar as conduct of arbitration proceeding is concerned, yes, time limit is provided, but the challenge is to stick to these timings. And here, I would say that two significant aspects which are to be kept in mind and which can go a long way in taking care of this time frame. One is, instead of ad hoc arbitration, if we have institutional arbitration, because in that case, and it should be even not limited to that the parties in their arbitration agreement are agreeing for a particular institution. That is a welcome move, that should happen. But in addition, I think if under section 11, applications dealing with these applications, High Courts and Supreme Court can refer the matters to such institutions, because much of the care is taken by the secretariat of the such MCIAs or other such institutions, and that can be provided. There is a provision for scrutiny of the arbitration, at least from this structured point of view, and there's no such mistakes apparent, not going into the merits of the decision which is given by the arbitral tribunal, which minimizes the chances of challenge to this award. And it may give some strength as far as, or some facilities for the arbitral tribunal to decide the case appropriately and early. Second aspect, which I said few days ago in one of the functions organized by ICC, is that it relates to the conduct of arbitration proceeding by the arbitral tribunal. And I think here some bold steps are to be taken. This is not our foray as far as judicial, because I'm talking of or discussing about the arbitration proceedings. But what I have read and what I emphasize there also, which I can say in nutshell here, because there can be a detailed discussion on that, that if you see as of now what happens in arbitration proceedings, unlike court proceedings. In court, it is a judge who is in charge of the court proceedings. He controls the proceedings. That doesn't happen in arbitral proceedings before the arbitral tribunal. It is the parties, as whether it comes to pleadings, detailed and verbose pleadings, evidence also, the affidavits are filed running into 1,000 pages, then cross-examination of the witnesses which may go on for days together, and how this has to be conducted in the arbitral tribunal, they would be only taking note of the proceedings. Arbitral tribunal should play, or the arbitrator should play more positive and effective role. This is said, actually there are three, which I read, three different authors who are great arbitrators in international field, and that is the recognition which they enjoy. One is David W. Rivkin, other is Michael E. Schneider, and the third is Kirill Narin, he is a QC. And they have described their approaches, which are almost the same, and therefore I'm not going to say each approach, but would sum up these approaches. Rivkin calls it town elder approach. Michael calls it commissioner model approach, as we have court commissioners. And Narin calls it diagnostic consultant approach. Now in these approaches, if I may sum up and summarize these approaches in few seconds, that instead of coming only after the pleadings are complete and issues are to be settled and joining the proceedings and thereafter sitting insofar as examination and cross-examination of witnesses which go on, including expert witnesses, which is one of the sessions here, the arbitrator would take charge of proceedings or would at least participate in the proceedings from very beginning. He will, and if I tell you in the nutshell in the beginning itself, it's a approach to some extent which I feel is taken from courts and to some extent mediation techniques also. He will have first meeting even when the pleadings are not complete and maybe statement of claim has come by the claimant that has been filed, and would discuss as to what are the issues, what are the business stakes, because there may be dispute between the parties, but the parties may like to go on with business relations, and what kind of decision is needed. And from that, he can curtail and issues, etc., claims, and after discussing this, it can lead to curtailment of the pleadings, the evidence on certain aspects where evidence may not be required at all. I can demonstrate it by giving detailed reasons, but that's not the time. But that's why I'm only emphasizing that a proactive role by the arbitrators is needed, and to that extent, and to give this authority to the arbitral tribunal, some changes or modification in the rules of the institutions are also needed. Now, I told you about the first instance of India jumping from 130 to 100. All of you know that there's one Mr. Amitabh Kant, who is the CEO of Niti Aayog. He had his write-up was also there 2 days ago in one of the newspapers. He's a friend, so I called him, congratulated him, and he said to me one thing: from 100, we can come to 70, or even we can go higher if one thing is done: enforcement of contracts by the judiciary. And some measures are required. So with that, when the arbitral award is passed, the third level at which, that is how we enforce the awards and how we enforce the contracts, where judiciary come into being. I was happy to hear that Delhi High Court is doing very well in that behalf. What is needed is, the government has also come out with commercial courts. Bombay High Court, Karnataka, Delhi, many others have set up commercial benches. What is required is that the judges who are also posted there, it should not be a routine, roster changes that one after other, but those who are well equipped with commercial laws and having that robust commercial sense. I should again admire my Chief Justice in putting in one of these benches, we have one or two benches, but main is where Justice Rohinton Nariman is given these cases. Let me tell you another example in the related sense as far as IBCs, Insolvency and Bankruptcy Code is concerned. Again, resolution process by the NCLT, National Company Law Tribunal, it has to be the timelines, I think 120 or 180 days is, 180 days is prescribed. But I can share with you, and when I find it, all those cases, it's a new code which has come into existence hardly, and operational it has become hardly 7 or 8 months ago. But all those causes which have landed up in the Supreme Court have been decided within 1 or 2 months from filing of the cases. I think 2 judgments I have authored, and 3 or 4 Justice Nariman has authored, which I have read in the news, in the reports. That's the kind of work culture which is required. And therefore, coming to the second instance which I said about our visit to SIAC, where SIAC was saying about all this, time has come where we can also boast. It was rightly mentioned that after Balco, as far as judgments are concerned, the judicial approach there has been a paradigm shift. There's an approach of minimum interference with the award. The judiciary has exhibited that, which is, I've seen in many journals worldwide, which is appreciated. Now, only problem is that delay, which is to be taken care of. And with this, I think these are some of the aspects where we have to give our attention to, and hopefully India would become hub of international arbitration as well. Thank you very much.
Thank you, sir, for sharing your views. Shri Suresh Prabhu, the Union Minister for Commerce and Industry, was unable to join us today. However, he has sent his regrets and, thanks to technology, a video message to address the audience.
Let me congratulate Mr. Madhukeshwar Desai for initiating this very brilliant idea of setting up Mumbai Central Center for Arbitration. Knowing this young man, Mr. Desai, I am not surprised by his innovative ideas. He's full of talent, versatility, initiatives, and therefore, obviously, he has come out with these very interesting ideas. I am sure we will continue to benefit from this. There are several business disputes which should go into alternate dispute redressal mechanism. Going to the civil court should be the last option because courts are already crowded with so many litigants already pending to get the verdict from them. If you have an alternate system which the Parliament of India created of arbitration, it will actually ensure that this will solve disputes speedily, reduce the burden on the courts, therefore others will get justice, and in the process we'll be able to solve this problem. But many times the arbitration goes abroad because people have faith in that. So we need to create good institutions in India, which people will have confidence and therefore they will come to this institution and therefore we'll be able to get a lot of benefits from that. So I wish to congratulate Mr. Desai once again. Unfortunately, I am traveling not in India. I am participating as a Commerce Minister of India into very important events globally. So please excuse me for not being here physically, but I can assure you one thing, we'll provide full support to this institution and ensure that such a young body matures soon to become a globally acceptable, globally respected, and globally renowned body through the sheer competence, integrity of the people who will operate it. Thank you very much.
It's always wonderful to hear support coming in from the government. Finally, may I please invite the Honorable Chief Justice of India, Mr. Justice Dipak Misra, to address the audience. Justice Misra has formerly headed the National Legal Services Authority and is the country's foremost proponent of arbitration, alternative dispute resolution, and even online dispute resolution.
My esteemed colleague, Justice Sikri, Chief Justice Manjula Chelu, Mr. Desai, Mr. Mandal, Ms. Sachdeva, judges from other courts, Honorable Judges of the High Court of Bombay, Mrs. Misra, Mrs. Sikri, ladies and gentlemen. I had a text, but I thought I shall speak to you. I was asking my wife in the morning why I've come here. This young lady, Niti Sachdeva, sent an email to me. I don't know her. I asked Justice Sikri. She said there's a good organization, MCIA. I'm aware of it, but I said, who is this person want to meet me? I don't meet people. She met me. I discussed certain things with her, and I agreed to come. I came. My purpose of coming here is my interest in arbitration as a facet of alternative dispute resolution system, and also believe in institutional arbitration. And if MCIA is doing institutional arbitration, they need commendations. I congratulate it. Second, the computer, young girl again, she said this is a young institution. The longevity of an institution is not the mark of credibility. Young or old, it's the temperament, it's the attitude, it's how you run it that matters. So please do not, for God's sake, call it young. Third, Mr. Desai, I don't know him personally. I'll talk to him. He quoted a line from Victor Hugo, a great French novelist. It's a beautiful line he quoted. When idea's time has come to stay, it stays. I will add to it, it not only stays, it conquers. The idea of institutional arbitration has come to stay in India. And therefore, Mr. Desai is correct in quoting Victor Hugo. Mr. Mandal showed many concerns. I will address only one concern of his, which also my esteemed brother echoed. It's a concern. An hour passed by, an arbitrator was passed the award through ad hoc arbitration, or an award which is passed through institutional mechanism or institutional arbitration cannot be a paper tiger. Enforcement is the cornerstone of any result that comes by arbitration or a decree of a court. Section 34 that has been amended in 2015 imposes the amount to be deposited I'm not there for the moment. My learned brother Sikri said, India has traveled from Bhatia to Balko. Bhatia created some confusion. Balko cleared everything, made it perspective. Then how do we deal with that interregnum period expressly or impliedly ruled out? He was a party to Reliance 1 and Reliance 2. I have written 2 independent judgments. I think the students of this country, and the students of this country means the students of arbitration law. One is Harmony, the other is Roger Suva. Indian courts are not scared of accepting the foreign jurisdiction if the parties agree by their agreement. If the arbitration clause refers to express elimination or implied ostracization, we have to accept it as interpreters of law. The confusion between the seat and the venue sometimes melts. In fact, in Harmony, we have explained, there are so many things have been added, how the English curial law and the substantive law would both be applicable. So we are marching ahead. Now coming back to Mr. Mandal's. Now, he praised the Delhi High Court correctly. Award is passed by Delhi High Court, made rule of court. They come in, specially petition, leave to appeal as you call it. The counsel hits hard. There are X, Y, Z, M points. I thought the best way, I've done this myself, to stop these challenges or to get the nectar of these challenges. One case there was an award of $650 million. I said, you deposit $350 million, we issue notice and direct stay of the rest, failing which the appeal goes. In one case they deposited, the other case they did not. And when the decree holder comes, we say, we throw the amount without prejudice. No bank guarantee, nothing. Realization of the amount is the most thing that matters to a litigant. That's the elan vital of any arbitration. So that's the point over here. Now let's come back. The growth of arbitration in India. I'm not going to tell you the history about 1872, what the West Bengal legislation did. I'm not going to say what the Britishers did thereafter. I'm not going to tell you what the Code of Civil Procedure added about an arbitration. I'm not saying about the growth of the 1940 Act, or we followed the ancestral model in 1996 Act. In 2015, amendment took place just to eradicate certain difficulties and also streamline. That apart, you see, I always feel economy is never static. Life is never stagnant. Economy and law move together. And when economy and life move together, the law comes as a conduit pipe to connect. And here, the 2015 Act has connected in 3 ways. One, first, anyone who goes for arbitration, he wants a speedy disposal. The amendment emphasizes on the time, extended time, that ensures that the arbitrator passes the award during that period. Thereafter, it curtails the fee, and for year some arbitrator does, it gives a bonus, a statutory bonus, recognized one. This one part, quickness. Second, cost effective. For the purpose of cost effective, there is a cap, and that is why the people are eager to take, not to take many arbitrations, but to finish them. Now the pressure is on. And second, now the arbitrator can award cost awards actual cost. Unless an adjudicatory process is cost effective, eventually it may not be helpful, and that purpose the amended act serves. Third, which is very important, to ensure objectivity and impartiality of the arbitrator. It makes an eligibility criteria, one. Second, disclosure. Third, removal. I'll tell you about the eligibility criteria. One case traveled to us. Under the contract, there is your postulate that managing director shall be the arbitrator or his nominee. The issue arose that the managing director is disqualified whether he can nominate X, Y, or Z. A great man, a great protagonist, a great jurist. The court answered, no. If you are ineligible to arbitrate as an arbitrator, you can't nominate an arbitrator. This stands in contradistinction to right to nominate an arbitrator as a party. Party nominating and self-arbitration are two different concepts. And the disclosure, I must share with you, has gone as almost a different kind of motivative injection. Do not do it, because eventually your award may be set aside. These are the safeguards that have been taken in the 2015 Act. Justice Sikri was my colleague in Delhi High Court while I was the Chief Justice. After I came, we amended the rules. The Delhi High Court has an arbitration center. The Court Adjunct Arbitration Center, presently it is named as Delhi High Court International Arbitration Center. They appoint arbitrators and ask them to function at the center. They are guided by those centers. This is court adjunct. That's different. I have traveled to 3 places in India. I have found private individuals, private sectors are getting into institutional arbitrations. They are yet to make much mark, but still the effort is on. This institution and there are other 2 in Delhi, they are really institutionalizing the arbitration. And actually, I must tell you, our act, our legislation provides an interregnum measure. An arbitrator, during the process of arbitration, can enter into mediation. Another mode he can also adopt. You see, what is mediation is not specifically defined in our jurisdiction. I attended a moot court competition where children from Singapore, Hong Kong, and other places, United States, UK, many European countries, they were addressing with regard to negotiation. Some of them really debated with regard to the amalgamation of companies, but some of them addressed with regard to solution of disputes. The arbitrator can take that role affirmatively by negotiating with them that you can settle. I'm not saying that he should impose upon them. Justice Sikri has told about 3 methods. All 3 methods, according to my understanding, can merge into one, a dialogue. Dialogue, ladies and gentlemen, stands on a different footing than monologue. Supposing the arbitrator listens to you for silence in 4 hours, meaningless. You don't know what's going on in his mind. May I digress for a while when I say about this monologue and dialogue? Sir Winston Churchill was the Prime Minister of India, Prime Minister of United Kingdom before India got independence. Attlee was a member of his cabinet. At one point of time, Attlee said, this decision was not discussed. How it has been affirmed. Churchill was imperialistic, a man of different character. He said, Mr. Attlee, this has been discussed on the last occasion. It's final. Attlee had to politely remind Churchill, but to no effect. Sir, a monologue is not a decision. A monologue is not a decision. Therefore, the arbitrators are required to have some dialogue on certain occasions during the process of arbitration. The other day, when the SIC meeting was there, and the minister has come, I said, there is no competition. In Asia, in Asia-Pacific region, there has to be collaboration. We must respect your institutional arbitration as I would expect you must respect ours. India is growing. Our economy is growing. We appoint today at the highest court the center to nominate. Sometimes we do nominate and send it to centers, but now sometimes people let center to nominate. But we really believe this institutional arbitration is more effective than ad hoc arbitration. And therefore, there has to be mutuality, respectability, and also to see how we really can improve the arbitration. There can be no doubt, time has come, India will take a pivotal place in the world of arbitration. Simultaneously, in the international field, we recognize the contribution of all concerned, and especially in Asia-Pacific region. And I'm sure this conference shall be a step towards that, and the young souls who have devoted their time, energy, and intellect towards the same shall make it a successful. And if they need any help by way of conference, discussion, definitely, if I don't have the time, Justice Sikri will be available, and if I have the time, I promise to come. Thank you for being present.
Thank you, sir, for your support and encouragement. May I now invite Neeti Sachdeva, the Registrar and Secretary General of the MCIA, to deliver closing remarks.
Thank you very much, Honorable Chief Justice of India, Justice Misra, for accepting our invitation to be here, to extend your support and to extend the support of Justice Sikri as well to this institution and to institutional arbitration. We really feel very encouraged, and we hope we will be getting back to you very soon to get more and more support from you. Thank you very much on that. Thank you, Justice Sikri, for your unrelenting support always. We, as younger generation of arbitration, as we call ourselves, are always happy to have your support and encouragement. Thank you, Mr. Mandal. We're very thankful to Mr. Suresh Prabhu as well, who could not join us in presence, but it is good to have the support of the Commerce Ministry as well and the encouragement. I would definitely like to thank Mrs. Chellu, the Honorable Chief Justice of Bombay High Court, the other judges of the Bombay High Court, Justice Tate, Justice Dhanuka, Justice Kulkarni, for being here and gracing the occasion. Thank you, Mrs. Misra and Mrs. Sikri, for your presence as well. We are very thankful for all of you to be present here and to make this conference a success. MCIA has made significant progress in the past year. But let me assure you, this is just the beginning. We have lots to achieve. We have over the past year spread awareness about MCIA tirelessly, and I am happy to report that there has been a significant rise and uptake in the use of MCIA rules. In fact, we see a trend where MCIA clauses are now being incorporated into drafting of clauses with India as a seat. We will continue to do the same in the coming year, and for the benefit of the participants present here, we'll be very happy to have discussion, meetings to discuss about MCIA rules. Please feel free to reach out to us anytime. We are delighted that not only the Indian community, but also the international community has welcomed MCIA with open arms. Within 6 months of its establishment, MCIA conducted its first international roadshow in London. We had over 75 participants attending the event hosted by White & Case in their London office. Who's who of the international arbitration world in the UK attended the lunch hosted by Clifford Chance. And we had various other law firms and the chambers of UK welcoming us and extending our support. We will continue to spread awareness about MCIA in India and continue to do roadshows in different parts of the jurisdiction of the world. In order to push the reach of the MCIA to different jurisdictions, we will, over the course of the following year, establish the MCIA Users Council to engage with experts and in-house counsel from India and different jurisdictions. The Users Council will serve as a soundboard for the MCIA to gather inputs on our rules, as well as for academic support, and for everyone to connect under the umbrella of the MCIA. I would like to conclude by narrating a story which I heard Mr. Fali Nariman deliver in an event. And here it goes. There was a sign on a shoe repair shop in downtown Boston, where it was run by an immigrant who was fed up of the complaints of the customer. So he put a signboard outside his shop, which was in a form of a triangle. On the top of the triangle was fast service, there was low price and high quality. And below was a line which said, pick any two. I assure you this could have been the situation of arbitration in India, but not anymore with the presence of MCIA. I'm delighted to report that the first matter which we got from the Supreme Court, we appointed an arbitrator within 72 hours of getting the reference. I assure you MCIA will continue to work efficiently, with high quality and at reasonable prices to make MCIA a world-class institution and India a preferred destination for arbitration. Needless to say, we seek your support, encouragement to do all of this. I thank you once again for joining us today, and we look forward to your support and active participation for the conference. Thank you very much, sir.